All right, thank you, counsel.
Thank you.
All right, the next case on our docket is School Board of Orange County against Orange County Classroom Teachers Association. Proceed when you're ready, sir.
Thank you, Your Honor. Your Honor, the school board appeals the denial of a motion to vacate an arbitration award, and it does so realizing that the path to that relief is narrow, but it does so knowing that the one thing that's established with respect to the reasons for which an arbitration award can be vacated is that the arbitrator exceeded her power, and specifically exceeded her power by ignoring the contract.
What is your name, sir?
I'm sorry, Tom Gonzalez, Your Honor.
Okay, thank you.
My apologies. And in this case, the school board alleges that the arbitrator exceeded her powers by ignoring the contract in three ways. First, by plainly allowing an untimely grievance to be processed. Second, by affording relief to grievants who were in fact not grievants because they had not been joined. And finally, by ordering the school board to do something which it had not the power to do, and that is to grant professional service contracts to employees who were on annual contract in terms of a statute that compelled that result that was not involved in the case. Beginning with the issue of the limitations period requires, I think...
So aren't you focusing on paragraph 9 of the collective bargaining agreement, is that correct?
Yes.
It was within the power of the parties to agree for an expanded time for the timeliness issue, correct?
Yes, sir.
Okay, and the arbitrator found that the time should be expanded, is that right?
No, sir. She did not find that. In fact, when you read the arbitrator's award, what she begins with is that it was reasonable for the union to conduct itself the way it is. And with respect to the expansion is the 3 days that specifically is provided for, that's allowed by agreement. And in the context of this case, it does not apply except to make clear that the contract contained the provisions with respect to the limitations and specifically allowed for an extension of 3 days. And under the decision of the arbitrator, you wouldn't need that. But in any event, even if it were to apply, Your Honor, the problem with the ruling and the fact of her ignoring the contract is made clear by the fact that even with that agreement, the grievance was not timely. And again, that requires us to return to where really, in a sense, this entire matter started, and that was at the oral argument in this court, in this room, on an earlier lawsuit, which was being litigated in lieu of a grievance being processed through the contract. And that was by agreement. And it was by agreement with respect to the party.
Well, wasn't it by agreement because the school board ultimately said, we're not going to agree through arbitration, to go through the arbitration process, we will appeal that judicially regardless of what the result is that correct?
I wouldn't put it that way. It was clear that the school board said one way or the other, a court's going to have to determine whether or not the statute says what it says. Yes, sir. And so there would be a motion to vacate if in fact there was, based on the fact that the school board did not have the power. And of course, it's in a sense, it's not relevant to your question, but in the event, the legislature came back and made clear that the school board was right with respect to its legal position on those contracts and whether or not a person who had been rehired after being retired could not get a professional service contract. But with respect to...
You're talking about the amendment that actually came into effect during the pendency of this issue, correct?
The clarification is what I'm referring to.
Amendment.
Yes,
The amendment that was lobbied for by the school board.
that's correct.
Okay.
Yes, sir, that's correct.
After the adverse ruling by the arbitrator.
Yes, sir.
Okay.
That's correct. And again, it is relevant in the context of making clear that because arbitrations don't have any binding precedent on other arbitrations, and because each person is required to have their own grievance filed on their behalf or for themselves, it is clear that that ruling would not have, that amendment would not have occurred in the pendency of this case. It might have occurred somewhere down the road, but in any event, it is something that could be relied on. And in the context of arbitration, Your Honor, the school board didn't have to agree to the ruling of the court. It could continue to maintain its position in the arbitration because the arbitration provision allows for that in the contract. It's a lot like the last pronouncement from our Supreme Court in the Jupiter Nurses Association, where it said that even the fact that a contract was illegal doesn't stop the enforcement of that contract, the required adherence to that contract of the arbitrator. And it stands for the proposition that we stand on here, and that is that the contract is the contract. And even if you take in the 3 days extra that's been referred to herein, and it's limited to 3 days, and it wasn't invoked, and it's not mentioned, it's not pled, in fact, the time is not satisfied. It is undisputed that on July 31st, 2012, the union was on notice that the school board was not going to apply Wachman to other cases. July 31st, 2012. Under the contract, they had 20 duty days to file a grievance, even allowing for the fact that they thought they could file a lawsuit, they thought they could do this. They did not do anything until February 14th, 2013, well past the 20 duty days, well past any 3-day agreement, and certainly well past any claim that the union was not on notice of the school district's position and the fact that there were these other people out there who might have the same grievance.
You talk about this 3-day extension in paragraph 9, but the last sentence in paragraph 9 that says the time limits prescribed herein may be modified by mutual agreement of the parties. So doesn't that mean that the 3-day extension that's granted can be modified by the party?
Yes, sir. Okay. But again, it takes a modification. And it wasn't used here, and there was nothing that suggests any finding or any assertion that there was a modification. This is all after the fact with respect to what they're talking about, because again, after waiting 6.5 months and then filing a declaratory action and having in response the district file something moving to compel arbitration because it believes that the matter should have been taken to arbitration, the union still is in repose. There's still no agreement to extend any time limits.
The arbitrator found that your side was equitably estopped from raising this issue of timeliness?
No, she did not.
There's no equitable estoppel?
No, sir, and there's certainly no equitable estoppel. Number one, equitable estoppel, we believe, is something that the union came up with after the fact to justify the fact that the arbitrator really doesn't deal with the entire time that was taken in this case, and does not rely on anything, and obviously in the context of someone filing a motion to compel arbitration, there can't be any basis for finding it. And if there were, it's taken away by the fact that on August the 12th of 2013, the circuit court granted the motion to compel arbitration, and after that, the union asked the school board the next day if it would raise timeliness. The school board said it hadn't decided yet, and there's no allegation of any kind of agreement. On August 19th, the union asked the court for an order clarifying whether or not timeliness was an issue, conceding that it had not filed a timely grievance. And then finally, on October 7th, 2013, the court ruled that the arbitrator could decide all issues, including timeliness. So there was no finding of anything that resembles waiver or anything else. There was a finding in the arbitration award that it was, quote, reasonable for the union to act the way they did. And we contend that it was not. And we contend that it was not because the one rule, the one given, the one reason why we can have a system of arbitration work in which there's no resort to a tribunal like this to make legal wrongs right in terms of decision making, or to undo facts which don't make sense. The price of that is there has to be adherence to that contract. And there was not adherence to this contract, and no one claimed that there was, up to the point where the union files a motion asking the circuit court to direct the arbitrator, to mandate the arbitrator, to decide the merits without regard to timeliness, and conceding that it had not filed the timely, and still taking no action to file that until November 25th, 2013. The cases cited by both parties all deal with the fact that clearly the findings of fact by an arbitrator, as misbegotten as they may be, and that the findings of conclusions of law, as wrong as they may be, are beyond the reach of this court. But all of those cases say, so long as the contract has been the guide that's been resorted to. And there's nothing in this contract which, in addition to providing for extensions by mutual agreement, and there's no contention ever made and found of any mutual agreement, and in addition to that, there's a provision that says that in the event that the union or the grievant does not meet a timeline, then the grievance is dropped. In the event that the management does not meet a response time, then it simply goes to the next stage. So there is a treatment in the contract of what happens in particular cases in terms of what goes on. And even then, even after being told that the Rockman decision would not be applied, even after being told that timeliness would be an issue, even after being told that the arbitrator could decide timeliness, the union never filed that grievance. And by doing so, it allowed an untimely grievance to be processed, which means that all of the things that talked about in the arbitration award about how the school district had some kind of obligation to be fair are meaningless, because they all presume that there's a grievance on which the school district can be fair. With respect to the issue of the unnamed grievance, again, it is clear that we are not talking about a court's decision, which may or may not have binding precedent in another court decision. We're talking about an arbitration. And we're talking about an arbitration that was filed on behalf of named people in the grievance, and yet was granted on behalf of people who were not named in the grievance. And we believe, again, the arbitrator exceeded her authority in that regard. And finally, with respect to the issue of the powers of the school board, the school board contends that whatever happened with respect to Rockman or anything else, it was not binding on future arbitrations. And it is clear, we believe, that the school board was right the first time when it said that someone who retires and comes back cannot be given a contract because the school board lacks the authority. And therefore, regardless of what is or is not the decision of this court, if this arbitration award stands, then the school board is going to be in a position of following through on giving a contract that we believe everybody has to agree they don't have the power to give, from at least the point where the clarification came. Thank you, Your Honor.
Okay, so you've got about 7 minutes left for rebuttal.
Please, the court, I'm Toby Lev. I'm representing the Orange County Classroom Teachers Association. With regard to the first issue on the timeliness of the grievance, we think the issue is decided by Schnurmacher versus Noriega from the Supreme Court. An arbitration award cannot be set aside for mere errors of judgment as to the law or the facts. The trial judge relied on Schnurmacher at pages 2161 and 2162 of the record. He found it wasn't a one-time waiver by the school board of its right to have this dispute resolved in circuit court, but an overall agreement as to how the dispute should be resolved. This is a collective bargaining agreement, but it involves contract principles, and contract principles apply with regard to arbitration and collective bargaining agreements, as they do any kind of contract. I would direct the court's attention to Phi Evergreen Woods LLC at page 18 of our brief, where the 5th DCA held that the contract principles apply, and contract principles include waiver and estoppel.
What findings did the arbitrator have as far as justifying the application of estoppel principles?
I'm just about ready to get into them. First, Ms. Rockman, who had basically the same case as everybody else, filed a grievance, and the school district said, let's not follow through with this grievance. We'll probably vacate it anyway if the arbitrator rules against us. Let's resolve this in circuit court. So we went to circuit court, and the school board never once said it belongs in arbitration, you have no jurisdiction. Then later on in the Rockman case, at oral argument, the school board's counsel said to this court that there are maybe 100 other teachers out there similarly situated to Ms. Rockman, and if she gets relief, they could get relief, and they're still within their statute of limitations to file deck actions. Now, when I hear that reinforces what I was told a year earlier, that resolving this issue by a deck action is the way that the district wants to go. After the decision in Rockman, the school board moved for rehearing, and in writing told the District Court of Appeal that, as it said in oral argument, there's up to 100 teachers that will be affected by this ruling, and they're all within the statute of limitations to follow their own deck actions. Now, if somebody's sitting there and hearing those representations, I would suggest he would not be thinking he had to run out and file a grievance within 20 days unless the school board came back and said, we've changed our mind, you need to arbitrate this, you can't go to circuit court, forget about a deck action. That never happened, and the arbitrator made all the findings which I just went through and said the union, in good faith, relied upon the school district's remarks and representations and conduct, and therefore filed a deck action, which it filed in February 2013. Even if the arbitrator got the facts wrong or the law wrong, or a judge might disagree with how she weighed the evidence or interpreted what somebody said, under Schnurmacher versus Noriega, her decision should not be vacated on that basis. It's important to look at the kind of right involved. This is a statutory right created under statute. The grievance had a right to a contract that vested under this statute before they ever had to file a grievance. The statute did not say by its terms that a teacher could earn a professional service contract, but it could be divested if she failed to enforce her right under the terms of any relevant collective bargaining agreement that might apply. On the contrary, the right is created by statute. The collective bargaining agreement only said that the school board would award professional service contracts as prescribed by statute. I would direct the court to the case of Gainey versus School Board of Liberty County from the 1st DCA at page 40 of our brief. Once a right to a continuing contract had vested, it cannot be divested by the device of obtaining the teacher's signature on an annual contract. So she has one already. She can't give it up through any means or device of the school board. It's a right that continued to be violated every day. The district did not provide a contract as prescribed by state law. The arbitrator said until the district reached this decision in Rockman, the right was not clearly prescribed under state law, which means that the time to file a grievance was after the 5th District Court of Appeal ruled, and as she found, the district had previously told the union that a deck action was the proper forum to resolve the dispute. So that is a kind of judgment by the arbitrator that cannot be disturbed. she said the words equitable estoppel only once in reference to the fact that the union claims equitable estoppel, but she made all the findings. She made the findings that the union was lulled into inaction, and she made the findings that the district never came to the union before the 20 days elapsed and said, you need to file a grievance. We changed our mind about a deck action. I want to address the allegation or the claim that the district can no longer award a professional service contract to the grievance. As the court may have read, after it lost the arbitration, it lobbied the legislature. I don't think the legislature went nearly as far as the district wanted it to go. What they're calling a clarification, I'm saying, is an amendment. Under the law, a legislative enactment is not retroactive unless by its terms it's clearly retroactive, and even then it can't be retroactive if it would have an unconstitutional effect upon people by depriving them of vested rights. We are talking about a statute that was enacted as early as 1978. The purpose then was to provide employment security to teachers via continuing or professional services contracts. That is the statute the grievance vested under prior to July 1st, 2011, when the legislature changed the statute to eliminate professional service contracts for new teachers. The only thing unclear then was whether if a teacher with a professional service contract leaves after July 1, 2011 and comes back in 2013 and says, I want to teach, is she a new teacher within the meaning of the 2011 statute, or did she have one before 2011, so she has one now? So that is a legitimate clarification with respect to teachers who leave Orange County schools after 2011 and come back. With respect to my grievance, it is a retroactive amendment of the statute. The legislature, none of these legislators were probably in the legislature in 1978. 30 years later, are purporting, according to the district, to clarify what the legislature intended in 1978 when they enacted a statute which had a completely different focus than what the legislature was concentrating on in 2011. So this is a right that the grievance had that vested prior to the July 1, 2011 Student Success Act, with the legislature clarified in 2016. We are not dealing here with a right created by a judicial decision. In that case, courts say that the underlying law upon which the decision was based can be changed any time until the judicial decision becomes final. Here we are concerned with a contractual right that vested prior to July 1, 2011. It had already vested before anybody ever filed a grievance or before this litigation commenced. The right does not vest when Orange County Schools finally recognizes it. It vests under the law, and the law said it vested prior to July 1, 2011. How much time do I have?
You have 10 minutes still, sir. You don't have to use all your time. It's not a requirement.
All right. I'll briefly
As
talk.
much as you like, Tom.
All right. I'll briefly talk about this class action issue. I think it's also should be decided under the Schnurmacher case. We're probably talking about a handful of people. But the arbitrator found that the form, which is in the record, the class action grievance, it said it was a class action in two different places. Then it becomes a question of weighing the evidence. If the form says that in a few places, but there's some other places in the form that don't suggest that, that's a question for the arbitrator to weigh.
Why didn't the complaint name all the 100 or however many more above 38? Why didn't the complaint name those people?
Of the additional people? We might be talking about only one or two. We got a list. We tried to ascertain who had who should have a professional service contract. We think we got just about everybody. My fear is one or two people fall between the cracks, and they come back later and say, why wasn't I included? So that was the basic reason we wanted to do it as a class action in the case of those people. Class actions in arbitration are not like class actions in circuit court for the same reason arbitrations were different than lawsuits. Arbitrations are supposed to be quicker, less expensive. There's not the kind of procedural requirements in a class action arbitration that there is in a circuit court arbitration. The district says it was surprised by the fact it was filed as a class action. The arbitrator said that in 2012, 3 years before the arbitration, you told a court that up to 100 people would be affected. That's a class of people. You're on notice about what the ruling could be and what the scope and effect of the ruling could be. Completely different from this Markowitz case where there was an element of surprise when on the morning of arbitration a employer which only thought one person was affected was suddenly looking at a case that could affect many people. I open the questions. All right, then I'm finished. Thank you.
All right, thank you, sir. All right, you've got 7 minutes left for rebuttal, Counselor.
Thank you, Your Honor.
Thank you, sir.
Your Honor, I'd rather go right to the issues that were mentioned with respect to this concept of estoppel and or waiver and or agreement, and note that we are talking about two different things with respect to this appeal, and that is regardless of what agreement there was or was not, and regardless of the scope of the agreement as to what device would be used, arbitration or judicial decision, that wasn't the issue of timeliness. There was nothing ever urged. There was nothing ever stated that there was an agreement or that anyone acted in any way that would lead someone to say that the time limits had been waived. Rockman came out of a timely filed grievance. A grievance level 3 meeting had to be canceled because it was ongoing at the time. And with respect to what was waived was with respect to that particular dispute, and that's made clear by the simple fact that the union sought permission to add another plaintiff, that is a grievant, to the Rockman litigation. And those are in the appendix to the brief and a part of the record with respect to the treatment of Rockman as being limited to those people. Moreover, whatever understanding the arbitrator wished to refer to, it is clear that as of July 31st, which is noted by the arbitrator, the union was on notice that no, the district would not apply the holding in Rockman to others. And so any agreement and any reasonable proceeding on that understanding is impossible under the facts of the case. With respect to the issue of notice, it's I guess as good a place as any to talk here about the fact that we have the union now arguing that the arbitrator noted that the district was on notice of the class action nature of this litigation because at the oral argument they answered a question with the knowledge that they had 100 other people who might be affected. What was in the record and is in the record is that in fact there were 40, and to the extent that the district was on notice of the class action because of its citation of a number, it therefore also was on notice that none of those people were named in the grievance, indicating that regardless of whatever their position was and for whatever reason, those people did not wish to participate, or for some other reason, but it does not matter because under the context of the case, in terms of what's happening, there is not any basis, and in fact, the arbitrator does not make an erroneous finding of fact. She simply doesn't cover the entire time that's required to be covered in order to there be any argument of estoppel or waiver. Because even after the 6.5 months which follow the union clearly being on notice that there were these other people out there and that the school board was not going to apply Rockman, there was inaction. And even when they file an untimely motion for deck action, because that too was untimely at the time, because again, there'd been no waiver of the time limits, and this district immediately responds by saying that they want to compel arbitration, and so the union is on notice again of the position and that there's no agreement to treat Rockman as any kind of binding throughout time kind of stipulation. And again, there's no action, and there is no action until well after the limitations period has passed. With respect to the issue of the class action, we said again that there were specifically named persons referred to as constituting whatever class was being asserted in that particular grievance, and they were listed, and these others were not, and there was nothing that was put on with respect to them as to any indication as to whether they did or did not wish to be included. And finally, with respect to the issue of the power of the school district, the decision in Rockman did not deal with the school code provision that deals with the issue. It dealt with the Florida retirement system issue. With respect to the issue of power, what is clear is that regardless of what it is or is not, it is in fact a statement that the school district did not have and does not have the power, and so whatever time period we're talking about, the school board will not have the authority to grant or maintain or to fail to end a professional service contract. Thank you again, Your Honor.
Thank you, Counselor.